is for judges to decide. I don't think I've had a custody case yet that before it proceeded to trial, at least one judge, or maybe even the trial judge, or multiple judges have given their speech to the parents, warning them about whether they really want to do this and how difficult it is for the judge to make a decision. And do you really want the judge to make a decision that may not be a good decision? I think most judges will acknowledge that they may not be making the best decision, and it might be better for the parents to rethink it and make another go at trying to settle it. And on top of that, I'd say it's difficult for the lawyers because the clients tend to be more emotionally charged. There's a lot at stake for them, and it puts a lot of pressure on the attorney to perform for the parent to try and help them achieve the result that they're looking for. And sometimes we can't do that.
Mm-hmm, mm-hmm. Yeah, well, everybody is not going to be happy probably in these.
No, and I think that's a message that judges often give before the trial is it's quite possible that the result will be one that both parents are unhappy with.
Mm-hmm, mm-hmm. Okay. What standard applies in making custody order judgments?
Well, the primary standard in an initial child custody order is best interests of the child or children. So it's a very broad concept looking at what really is best for the children. It's not the convenience of the parents, although in negotiations, often the negotiation is from the standpoint of the convenience or needs of the parents. But once you go to court and the judge makes a decision, the standard is best interests of the child or children. Mm-hmm. In a case where there's already a custody order in place and someone is trying to change it or modify it, the standard may be different depending on whether the existing order is a temporary versus a permanent order. And I don't know if you want me to get too deeply into this. Mm-hmm. The standard for modifying a temporary order is, again, best interests of the child. If there is a permanent custody order, the standard is elevated somewhat, and the moving party needs to show a substantial change in circumstances. So something more than just best interests.
Mm-hmm. Okay. Okay, one of the things, again, emotionally charged is when you have a visitation as a condition. And so the question is, when will supervised visitation apply in these cases?
Okay, well, supervised visitation is something you'd see in where there's more extreme conflict. It may or may not be justified. It's often something that happens early on in the course of a case where there are serious allegations of child abuse or a neglectful parent. It could be drug abuse, habitual alcohol abuse, or something that really affects the child's safety issues. Parent maybe perhaps not giving medication improperly, some level of incompetence by a parent. And so in those cases, if there's justification found by the court or someone working for the court at Family Court Services, who would be a mental health professional doing some sort of a quick evaluation, the recommendation may be for supervised visitation where a parent is not permitted to be with the child without somebody there to actually watch them and make sure they're not engaging in whatever conduct it's suspected they may be endangering the child with.
Mm-hmm. Okay. All right, so when you have these supervised visitation requirements, who's the supervisor?
Well, sometimes it's negotiated, and it could be as simple as a friend, a neighbor, a parent, a grandparent. Often people will agree on relatives. If it's not a real serious case of neglect or abuse, the parent who's alleging the other parent needs supervision might agree to let some relative of the supervised parent actually conduct the supervision more informally. In more serious cases, or where you cannot agree on a supervisor, a relative, a friend, there are companies, private companies, that actually perform these services. There are several of them, and at a fee, at an hourly rate, they will provide someone who is trained to supervise the parent and will actually be there from delivery of the child to return to the child. In the case of a supervision where the parent's permitted to maybe have their visits at home or outside of public place. And then there are other cases where the supervision is required to take place at a supervision center, where the child is dropped off, meets the parent there, and is in a closed environment in a building that they're not permitted to leave.
Wow.
And that can be very expensive.
Yeah. Wow. Okay, well, when you have this type of requirement, the supervised visitation, how long does the requirement tend to apply?
That could be all over the place. I've seen it apply for years. I guess theoretically, in some cases, it could apply forever if there was some determination that a parent really was an existing danger for a child and would continue to be so. Typically, what I see is these cases are made in the preliminary stages while the dissolution is going on, and the parent who allegedly needs supervision meets certain conditions. When they've met those conditions, then the supervision is phased out. For example, say the allegation is the parent has a problem abusing alcohol, and maybe the court order says there's going to be supervision and that parent will undergo a test to see if they're using alcohol at the end of each visit, and provided they go through a period of months of clean tests and maybe attend AA meetings or engage in some sort of court-ordered therapy, at some point, if they've shown that they can follow the rules, then the supervision may end. It would depend on the nature of the problem. A lot of cases you see drug testing, either regular drug testing or random drug testing, and if someone's able to demonstrate over a period of time that they've addressed the problem, or maybe shown that there was never a problem to begin with, then the supervision may end. I mean, what I see in some of these cases, I think the allegations made against the parent who's put under supervision turn out to not be legitimate, and maybe the parent making the allegations has made them up completely, or perhaps they've exaggerated them in their own mind and the problem isn't as great as they think it is, and the parent who wrongfully is put under supervision at some point can show that it's not justified and that they are safe with the child.
Okay. What input does the child have on custody decisions?
Well, in terms of real input, the law says that when a child is of a sufficient age and maturity that they are able to express an intelligent preference, that the court shall give weight to that child's preference. So even in that case, it doesn't mean the court has to follow what the child wants, but they're supposed to give weight to it. Now, in reality, judges rarely, if ever, actually meet the children or hear from them, so that child's preference is filtered through a neutral investigator, normally a mental health professional appointed by the court to perform an evaluation or an assessment. And so that child expressing a preference will, I guess the evaluator then will determine what weight they think should be given to it, or does the child have an intelligent preference. If you ask most attorneys, I think most of us would say the magic age is probably in the range of age 12, but the statutory framework does not give us a specific age. So you may have an articulate 10-year-old who is able to express themselves intelligently and have some strong opinion that might carry some weight, and you may have a 13 or 14-year-old that you might not give much weight to if you don't think it's a truly intelligent decision that the child is making.
But you don't